Hello, everybody. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you for participating in today's event, our community conversation entitled Selecting an Attorney with Your HOA, selecting and working with your HOA attorney. Get it out. ECHO is a 50-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, slides were sent to registered attendees. Please take a moment to familiarize yourself with the housekeeping rules. Today, we have a large audience of HOA board members. We will do our best to answer your questions, but we may run out of time. Please use the Q&A feature to ask your questions. Once there, use the upvote feature, the thumbs up icon, to vote for your favorite questions. We will answer the most popular questions first. We ask that you keep your questions general in nature and short. Questions about specific situations are better asked of the attorney serving your association or the appropriate industry professional familiar with your specific situation. During the presentation, we will respond in writing to some questions during the presentation. All other questions will be answered during the Q&A session at the end of the presentation. The chat icon is to be used to report technical issues and to communicate directly with other panelists in the webinar. We do not monitor the chat feature for questions. Now let me direct your attention to our monitor where you'll find our disclaimer. None of what is said during this seminar shall be construed as specific legal advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you for that. This event, as well as all of our events, is made possible by the generous support of ECHO HOA professional service providers. Join me in thanking today's sponsor. Our program sponsor is CM Squared, and the registration sponsors are Birding Weil LLP and Levy Erlinger and Company LLP CPAs. And now a few words on behalf of John Rivera of CM Squared. CM Squared Inc. provides architectural design services, forensic investigations, building assessments, reserve studies, asset management, engineering, and project and construction management services for multifamily development communities. They have a rich knowledge of the latest post-litigation repair design methods and material alternatives, which enables us and enables CM Squared to provide superior solutions for complex architectural and engineering challenges. Our unique repair design approach is recognized industry-wide. We have mobilized over $50 million of construction repairs, utilizing the most current architectural, engineering, and building code standards of excellence in both quality and performance. And please support all ECHO professional members and especially our sponsors. They make our educational programming possible at little or no cost to you. And now let's go on with today's program. Steve Weil, our speaker today, is a principal, founder, and executive committee member of the HOA law firm Birding Weil LLP. Steve has practiced community association law since 1984 and has helped clients address many challenging situations in association management through his 40 years of professional service. His practice has focused on construction defect claims and day-to-day general counsel, including the application and enforcement of the Davis-Sterling Act and other laws affecting HOAs and common interest community welfare. Steve served on the ECHO Board of Directors for many years and continues to support ECHO and its mission to foster a better quality of life and community association. Steve was elected by his peers as the president of the College of Community Association Lawyers, which is a national society of HOA Association attorneys and one of the highest honors bestowed upon attorneys in the HOA legal profession. Steve, please take it away.
Thank you, David. I appreciate that. And I see we have over 100 participants. Very good turnout, as is very common for ECHO programs that I've been fortunate to be a part of and also to observe. So let's get into it. Working with an attorney. Here's a question that comes up a lot. Who does the attorney work for? And the answer is the attorney works for the association, acting through the board of directors. So the question comes up, well, does the lawyer represent an individual director or even the board? Members sometimes say, well, I pay the lawyers fees because my assessments are used for that. And the answer to all of those cases is no. Like in any corporate environment, the lawyer is the lawyer for the corporation, and the corporation speaks through its board of directors. And sometimes, frankly, that's a little challenging when the lawyer has to say something that, the board may not like or an individual may not like, but that's just part of the job. And we hope that that will enhance the lawyer's credibility when they answer questions in that way, as opposed to, to satisfy an individual director. A question that comes up, another that comes up a lot is, well, are you the lawyer for the management company or the manager? And the answer is a most emphatic no. A lawyer should not be representing the manager if they're representing the association. Now, the reality is it is rare for conflicts to arise, but just for clarity's sake, the lawyer only has one client, and that is the association. Now, that said, the reality is that lawyers who represent associations get many referrals from management companies. And in fact, many times the lawyer may not even know who the directors are. And so there's a close relationship there. But there should be no doubt in the board's mind or the manager's mind that the lawyer is representing the association and not the manager. And if there's a question about that, or if the board is uncomfortable or thinks there's something going on, between the lawyer and the manager, then that's the time to have a dialogue. Because if you don't trust the lawyer to be making advice, conclusions, all that for the board, acting on behalf of the client, then frankly, you need another lawyer or you need another manager. Let's see the next screen. So a standard of care is the way that we evaluate whether someone has complied with their responsibility. So for example, if a landscaper, you have a landscape contract, the standard of care is contained in the contract. They're supposed to come out so many times. They're supposed to treat the soil in such and such a way. And in addition, we have what's called the reasonable care standard, which means that has the lawyer provided the quality of legal advice consistent with or exceeding other lawyers who are in that same area of expertise, so community association law, and in the geographic area, which could be the Bay Area, could be Northern California, could be the state. I mean, it depends on a lot of different issues. But the lawyer doesn't make any guarantee and only gives, expressions of opinion only. This reminds me of a funny story. My father was on the board of directors of a community up in Sonoma, and he thought that their lawyer should always work on a contingency basis, even when there wasn't any money involved. I don't know what that meant. But yeah, so the lawyers, there are no guarantees was really my point. We lawyers, we want to help the board, we want to help the community, but some things you can't control. Sometimes you don't know what a judge is going to do or say. So we're just giving the best opinions that we possibly can. That said, if you look at the fourth bullet point there, Unlike any other vendor, a lawyer cannot ask the association for indemnification. So in other words, if the lawyer gets sued because of something the lawyer did for the association, the lawyer can't say, hey, association, I did that for you, so you should defend and protect me and pay legal fees or settlements or judgments. The lawyers are completely out there on their own. So what to expect from your attorney is really something we're going to talk about all throughout our program today, and hopefully there'll be questions like that in the Q&A as well. What you should expect is candor, responsiveness, a willingness to respond to an ASAP emergency. You should also expect a good lawyer to say, it doesn't look to me like this request you have is ASAP, is it really? Because the lawyers, we get so many incoming requests, we try to manage our time, to serve the clients the best way we can. And sometimes that means if your client has an emergency, then we want to push our priority list down a little bit so we can get to your client. That's the kind of thing I think you can expect from your lawyer. Sometimes you can expect estimates of legal fees, and I'll speak to that a little bit later. And sometimes you won't be able to get estimates as well. But at the end of the day, what you really should expect from your lawyer is responsiveness, reasonable competence, and complete dedication to the needs of the board. And also, you should expect that if the board has decided to do a thing that the lawyer didn't recommend, you want to make sure the lawyer is prepared, nevertheless, to step up and defend the board and the board's position in the association. The lawyer doesn't get to choose or veto what a board does or doesn't do. And if you have a lawyer that acts that way or says that stuff, again, you need a different lawyer. Connor, let me see the next slide. So we hear this phrase a lot, general counsel, and I noticed it, even I used it, I think maybe in that introduction I sent over to Dave and Connor. There is a difference between corporate counsel and general counsel. In our industry, everybody uses the phrase general counsel, but it's not technically accurate. Someone who is a general counsel has an affirmative duty to reach out to a client and tell that client something, warn them about something, give them a heads up about something, even if the client has not asked. So for example, a city attorney is more like a general counsel. And all of that is contrasted with what we are, really corporate counsel, which means we respond to questions. So if a client directly through the board, the authorized director or the manager sends the lawyer an email and says, hey, we have a problem with parking here. Would you look into it and tell us what the current towing rules are? That's when we serve as corporate counsel, responding to that question. Now, where this comes up is in the context of new legislation and governing documents. So, for example, the current law is that a rental restriction, that is unreasonably restrictive violates the law and needs to be changed. That was based on a civil code section in Davis Sterling a couple of years ago. Well, that doesn't mean that your lawyer should be going through your CC&Rs without you asking and alerting you to the fact that, hey, you need to change Article 3, Section 2, because it has a 1-year occupancy rule before anyone can lease. That's probably unlawful, which is true. It's not the lawyer's job to go through every client's documents and alert the board to an issue. On the other hand, if the manager or the board writes to the lawyer and says, hey, we heard about this new law about rental restrictions, what's that about? Then, of course, the lawyer's should say, well, yes, the legislature has adopted several laws recently that limit the ability of the board to restrict rentals. And if you like, I can look in your governing documents and tell you whether or not, your documents conform to the law. So that's the difference really between corporate counsel, we do what we're asked, and general counsel, which is we volunteer stuff without anybody asking. So generally speaking, the lawyer's tasks are not task driven. I mean, I know we all expect the lawyer is going to do a task by, preparing a ballot or providing the board with a legal opinion. But the real work is in the judgment and analysis of risk issues, identifying and all of that leading up to options that a board may take. For example, a board needs to raise $3 million. Is a membership vote required? Sometimes yes, sometimes no, it depends on the purpose. Is it a capital improvement? If it is, then what are the percentages of approval? And what if we move forward without getting the right percentages anyway? And if we're going to get a loan, do we need the members to approve that? And if we do, or if we don't, and that. So we want the lawyer to be able to have the good radar, not just to know what the issues are. And in law school, we call this issue spotting, but also to advise the board of well, if you do this, these things could happen. And if you do this other path, these things could happen. And that way the board can do what it is required by its fiduciary duty to do. And that is to weigh the options and decide the consequences. That's not for the lawyers to do. And we don't really always know, what the influences are in a community the way directors would. We will never know your community the way you do. And so you need to bring your expertise and experience and your sense of the community to the analysis and the options and consequences, that we lawyers should be talking about. And obviously, once the board decides on a course of action, it's our task, if the board wants, and to the degree the board wants, to assist in implementing a board policy. Hunter? So how do we do what we do? The first thing is we get information. We may ask for records. We may ask for records that may not seem relevant to the board or manager, but which the lawyer, based on their training, may think are relevant. And that information may be contained in records and emails and minutes and photos and that kind of stuff. So, for example, if we have a CCR enforcement question about somebody parking a commercial vehicle in the driveway, let's say that's prohibited in the association's governing documents. Well, the lawyer may want to ask, well, what other kinds of enforcement challenges do you have? Well, we really don't care if people, paint their house without asking us the color, or they put in landscaping without permission, so long as nobody objects. Well, the lawyer wants the whole picture, because if you're going to tangle with somebody on enforcement, one of the biggest and most common owner defenses are, well, you're picking on me and you're selectively enforcing this parking provision, but you're really not enforcing these other provisions, and that's not fair. So sometimes we may ask for information that seems broader. I know that there are directors and managers who think that if we give the lawyer the information that we think is relevant, that will be a good way to save money. And I hope that if you have a lawyer, they would say, thanks for that, but I also need this, this, and this. And the lawyer should be able to explain why in a way that makes sense. Many times, a director will write me and they'll ask me a question about something, I don't know, let's say capital improvements. And they'll cut and paste the section of the bylaws or CC&Rs dealing with that. And they'll want me to provide an opinion just based on that paragraph. But I might need to know a lot more than that. I want to verify that we're looking at the current CC&Rs. I want to know what the history is. I want to know whether the entire project is new or whether just a portion of it is new. For example, if we're redoing a guard gate and we're going to be putting in a restroom where one isn't there, well, the guardhouse, that's not new. So that might not be part of the capital improvement equation, whereas the restroom, if we put it in, would be. So we lawyers need to have the entire universe of information, and that will ultimately save the client money, not cost them significantly more. And what we're doing in all this, third bullet, is We're looking for issues that are out there, and that's our job to do it, whether the client raises it or not. For example, let's say there's a dispute between two residents, Mr. Upstairs and Mrs. Downstairs, concerning a noisy floor. And, you know, one of them, the resident below is accusing the directors of not enforcing the nuisance clause, or not enforcing the requirements concerning no increase of sound in the context of, a homeowner putting in hardwood flooring. And it turns out that, when this issue first came up, the upstairs owner claimed they were being picked on because of their country of origin. Well, the lawyer needs to know that, because the current law in our state and elsewhere is that when there is a CC&R dispute and someone raises the concept that they're being harassed or picked on because they're in a protected class, whatever it might be, then that changes the analysis, or could change the analysis that the lawyer is performing. So we're looking for issues like that. And obviously, we're doing legal research. And what does that mean? Well, we're going to look at the Common Interest Development Open Meeting Act. If it's a meeting question, we're going to look at the Davis-Sterling Act. We're going to look at the Fair Housing Amendments Act of 1988, or the California equivalent discrimination law, Fair Employment and Housing. And then sometimes we're going to do case law research. And the cases may not shed any light on something, or they may. But that is why we do the research. And then how do we get that research to the board? Well, it depends. It could be, it comes by email. It could be the lawyer will think, I think I should send this in a letter. And it could be, first, before I do anything in writing, I'd like to have a meeting with the board. And there are reasons why we would do each of those. I'll just speak to the issue of the letter and the meeting. A letter is a way that we lawyers communicate to you, hey, this is important. This is not casual. We all can email each other, but now you have a letter from counsel. That's a radar button at your end. This is important. The other thing is, in my experience, it's a lot easier for managers and directors to have institutional history when the communication is by email than as opposed if it's just a part of a letter chain. Why do we have meetings before we write opinions? Because sometimes the information that we have just doesn't give us enough. It doesn't tell us enough about the context of issues. If a homeowner in the community has been demanding records and the board or the manager has provided some, not all, and they're late and that, usually if there's a big argument over records production, there's something underneath that, which could explode at any point. And so maybe it's a delicate issue, depending. So that's a thing maybe I'd want to talk to the board about. There are lots of examples, where that comes up. The other thing that we do frequently, lawyers, is we ghostwrite letters to the members. We'll obviously draft ballots. We may prepare Q&A, question and answer letters or memos. Like, let's say the board was going to propose a governing documents amendment, or there's going to be a vote on a capital improvement, a loan, whatever, construction defect litigation. And so we lawyers are asked to write a letter to the members. And sometimes we're asked to write it on our letterhead. And sometimes we're asked to write it on the association's letterhead. We're ghostwriting it, in which case the board needs to approve it. And honestly, I find it much harder to write a letter to the members in the board's voice than it is just to write to the board in the lawyer's voice. It takes longer. It's going to be deconstructed a lot differently. Everybody's going to have an opinion on it. You want to anticipate and then address what members are going to ask, what they're going to say, what the objections to a form of action are. So capturing that frequently will take 2 or 3 or 4 different drafts, input from directors, modification based on a whole bunch of things. So that is definitely a very hard thing to do, in my opinion, to do it well. Connor, what's next? So we lawyers, we want the work. Right? So if you call us and say, it looks like we've got a possible landslide above 4 of the homes in the community, what do you think that's going to cost? Believe me, the lawyer, you want a lawyer that will take the call or take the short email, and that will save time, because then, you know, either the board or the manager will already have that much financial authority, you know, or you know, they will quickly get that authority from the board. So a short call saves time, and the lawyers need to know the context, not just the simple question. If you narrow the question, you are not going to get the best legal advice you can get. So for example, in my hypothetical about we have a possible landslide, well, turns out the project up above is doing a lot of construction. There's a concrete V-ditch, it's cracked, and, you know, we don't know if it's leaking. Or last year we had an engineer, you know, redo, you know, with a soils contractor redo the hill. And now, you know, we're worried about, is it sloughing? We have another issue. We have insurance concerns. We don't want to blemish our record. So don't just ask the question, what's the duty for a landslide? It's always good to give the lawyer the context. And in that regard, you want to be sure that you and the lawyer understand what the lawyer's job is. If we think it's bigger, then we need to tell you in a nice way, you're not asking the right question, or the questions you're asking, they're not complete. We need to know more. On the other hand, if we answer the very limited question you ask, you may ultimately be unsatisfied. Well, you didn't really tell us what we needed to know. So we really want to be sure we have a good handle on, you know, we're all on the same page about what the lawyer is supposed to do. This next bullet point is crazy driving, not just for lawyers, but for any outside service provider you're using. The landscaper is a really good example as well. And that is, who has the right to speak for the board? When you have a written agreement with your lawyer, and the law doesn't require that you do because you're a corporation, but if you have a written agreement, that agreement should say who gets to speak for the board. Now, usually that will be the president and or the manager. The lawyers, we don't care who it is, but we want you to tell us, because sooner or later, we will get a call from somebody who we don't know, and they're on the board. They say they're on the board, assume they are, and they will ask a question, and we won't know the context, and they may sound like they're reasonable, they may not be. They may want to leverage the opinion given on the phone by the lawyer, and you know, for some political argument, an internal political argument, or to tee up you know, the rest of the directors or the president or the manager. Usually it's a very political issue. We lawyers don't want to wade into that, and you don't want us to wade into it any more than you want a director telling the landscaper, hey, cut those trees over there, and the landscaper doesn't know what to do. That's not in my contract. Do I get to charge more for that? Am I authorized to do that? If I do that, will they make somebody else mad? So you want to be careful about that. Another sort of tip about how to manage lawyers is the ASAP and the emergency button. In my experience, not all of the emails that I get that are marked urgent or marked ASAP really are urgent or really are ASAP. And you don't want to be like, you know, the boy that cried wolf. Part of it, again, is we need to prioritize our work. Any lawyer that's any good is going to be busy. If they're not busy, probably not a very good lawyer. So you want to help the lawyer prioritize so that when you actually do have an emergency, that lawyer will drop everything and will get you either the complete answer you need or enough for your meeting if it's, you know, tomorrow morning or later this evening. So you want to be respectful of that emergency and ASAP button. Connor, let's go to the next one. So attorney fees are fees that we charge for a service. And that service may be, responding to an email, attending a meeting, something involving an analysis. Costs are money that we spend in connection with the job we're doing for you. So a very obvious cost is if we're going to be recording a lien, and the recorder's office will charge $15, whatever they charge. If we're going to file a lawsuit, there are filing fees. If you're in a lawsuit, there are depositions, the court reporter charges. Those are all costs. You can think of them as out-of-pocket expenses, photocopying, service of subpoenas, and that. So most lawyers will say in the normal day-to-day work, fees and costs are separate. You got to pay the both of them, and we don't charge a markup. I can't imagine that a lawyer would. If they do, I would say no. That sort of thing. In the construction defect work, which is what most of the work that our firm does, fees usually are contingency. I'll talk about that later. And costs include things like testing costs and the monies we pay to architects and engineers to help, with the forensic investigation. So what influences fees and costs? And I know you're thinking in your mind, well, it's the hourly rate. And I'm going to tell you, it's generally not. Lawyers who have experience are worth more in the market, and we charge more. Lawyers who are less experienced but are part of a good firm that gets good supervision and training, they're going to be charged less with a senior lawyer supervising. So as an example, as Dave had to tell you twice, yes, I've been doing this 40 years. I don't like to admit that anymore, but you don't need me to write a letter to somebody about a barking dog. So that's something I would explain to my associate, here's a task, and then she or he, could do the letter and the communications with the owner. Where you would need somebody who has greater expertise and political radar in communities is when we've got a very hot political issue, when there are significant legal challenges to a board, if there are complicated legal issues, cases are varying. If the other side has a lawyer and it's obvious there are going to be, litigation threats, that's where paying the extra, whatever it is, 10, 20, 30, 40, 50, $100 between, an associate and a partner will save you money, will not result in unnecessarily higher fees. The other thing that drives us bonkers is when the information we get, we were assured was complete and it's not. And the only way we know that is when we do the opinion letter, somebody calls back and says, well, what about this? You didn't consider this. Here's a photo of this condition. Well, frankly, we don't want to criticize the president who sent us the info incomplete or the manager. We don't do that. But that is one of the reasons why then we have to go back. So that's why we try to get all the information that we need in the beginning. How will the analysis be used and what is safe harbor? So if there is a $100,000 question, we're going to be extremely careful. If the question involves something that's really small, you're going to get a fast answer and probably something like, try this, and if it goes sideways, give me a call back. If there's an analysis that's going to be used time and time and time again, you want the lawyers to be especially careful. And because it's going to be part of now the institutional lore. I'll tell you a funny story, true story. A few years ago, a manager called me the night of an annual meeting, and she said, hey, Steve, we have a lot of members over in Europe. They're faxing in the ballots. Is that okay? And I said to her, no, that is not okay, because under the Davis-Sterling Act, all votes are secret and they have to be mailed in the ballot, and then they're opened at the open meeting. and nobody's supposed to know. She said, well, we have our meeting tonight. I said to her, okay, are there any big problems going on in the community? No. Is this a contentious election? No. Is it a contested election? Yes. There are 4 people running for 3 seats, but everybody gets along. And if one of the 4 didn't win, they'd probably join a committee. I said, have you done this method of voting in the past? She said, yeah. So I said, okay, because I want to take care of the manager. So I write, and the manager and the board were very close. So I write her and I say, okay, you told me this. It doesn't conform to the Davis-Sterling Act. However, I understand the risk is very low. There aren't any hot issues. You've done this before, so I think you're good. So I think I've done a good job. The community goes on, the meeting happens, and we're done. A year later, same manager calls me, same issue. I said to her, well, no, Davis, and after that, I've given hundreds of opinions, in the year since then, maybe 1,000, who knows. And I said to her, wait a minute, you can't do that. It's got to be single. Oh, she says, oh, no, Steve, I have your letter from last year saying it was perfectly fine. So my point is, we lawyers want to know how you're going to use the analysis. And if it's going to be something super important, you're probably going to be charged more. Safe harbor is the concept that once you have a legal opinion, you can rely on it. And that will be very, for your fiduciary duty, even if the lawyer turns out to be wrong. If you relied on the lawyer and acted in good faith, then you're doing fine. When the issues are unclear, the bill will be longer. The work will be harder. The bill will be higher if we're trying to really get into the weeds on what the legal issues of some complicated thing might be, and if so, what the risks are of doing one thing or another. We had a lot of that a few years ago, where we had the legislature adopt the voting rules, and they would frequently conflict with what were in the bylaws and CC&Rs, and so there were some challenges there. Forums for resolution. So if you're asking the lawyer to show up for one meeting, okay, we know what that cost is. If we're involved in a dispute with a homeowner and there's going to be a lot of back and forth and there are a lot of meetings, we can't predict that, and the costs are going to be higher. And again, as I mentioned before, member communications are tough. Yeah. Connor, let's see what's next. So, okay, there are different ways that we charge. Hourly, obviously, and hourly rates are, we write down in a bill our time, and then, we're being paid for our time. Sometimes we can provide a client with a not to exceed estimate or a flat fee. And really what that depends on is whether we know all the facts. So for example, if the board is asking us to prepare an opinion letter on capital improvements, I know what that's going to cost once I get the information and I say it'll be between X and Y, or it won't exceed Y, whatever it is. But if there's going to be pushback from the members of the board, if we're doing governing document amendments and we have 3 or 4 or 5 meetings because the members don't understand them, or they got upset about a particular provision, a rental restriction or no smoking or something, and then they want legal justification for it. They want the lawyer to come to another meeting. Again, it's not possible to really accurately estimate that for anybody. The short way of thinking of it is, if the lawyer can control the pieces on the board, you can get a fixed fee or a not to exceed fee. And if we can't, then you're going to get a range, and we're going to hope that it's within that range. No guarantees. Contingency fees. So contingency fees are very common in our construction defect cases, and basically make the lawyer and the client partners in the construction defect suit. If there's a successful recovery, the lawyer will get a percentage only if and when that recovery comes through. And if there's no recovery, the lawyer doesn't get paid, and then that's just the business risk for doing that. In my experience, a client will usually, not always, come out better if they pay on the hour. I don't know, maybe 10 years ago, I did an analysis of our hourly cases and contingency cases. And we do a lot of this work. I think we've recovered something like $1.7 billion since we opened our doors in 1988. And I found that the hourly clients paid bouncing around 15%, whereas the contingencies, depending on a whole host of issues, are in the 20 to 40% scenario. 40% being where the chances of winning are very, very low, very, very low success. So all of these things are negotiable. Of course, the lawyer gets more money because we're waiting a year, 2 years, rarely, but sometimes more to get paid. We're taking the risk that there will be no recovery. We're taking the risk that we'll have to try the case, which takes an awful lot of extra time. Many times you'll see in a contingency fee contract, a percentage will increase in sort of the later stages because a great deal of work needs to be done there to prepare for trial. It's not practical to do contingency work in any other scenario other than construction litigation, in my experience. Obviously, if we're talking about CCR enforcement cases, the prevailing party is entitled to an award of the legal fees and costs. Sometimes that's what the lawyer charges. Sometimes it's not, because judges get to do what they want to do. And frankly, not many of them are very versed in HOA law, and they usually are unhappy and they have to preside over enforcement cases because, they just think we should all work them out, in mediation or something where they've got divorces and murders and stuff. So we don't always get all of our attorney fees back, even though the fees may be legitimate, normal, reasonable, all of that. Connor? All right. So what about these communications? So whether it says so or not, communication from the lawyer to the client is protected by the attorney-client privilege, which means that the lawyer can't disclose it, and it should not be disclosed unless the board authorizes that. So, and I'll come back to that in a minute. So most lawyers will write in their letters privileged and confidential, like, in the top of the letter. It doesn't matter whether it says that or not. It's privileged and it's confidential. And you want that because you want to be able to have the lawyer feel comfortable giving you the upsides and the downsides and the risks of the issues that, are being addressed. If the lawyer thinks the letters are going to be disclosed to the world, then we write the letter differently and you don't get the best advice you can get, because we don't want to write something that's going to be used, by opponents in ways that would be harmful, to the association. Now, the Davis-Sterling Act recognizes the importance of boards having the luxury of considering several things confidentially. And that's why the Davis-Sterling Act says the board can meet in executive session, and you all know this, for potential litigation, contract formation, with some foreclosure assessment issues, and then like for member discipline. But if you construe Davis-Sterling strictly, they would not say that the board confer confidentially with a lawyer, except for basically contract formation, member discipline, or litigation, or potential litigation. But there are a lot of issues where the board needs confidential legal advice. For example, analyzing a capital improvement issue or a fair housing issue, that. And so what our position is, and I think all good lawyers would say this, is the board has the right to meet in executive session to address any legal issue with a lawyer. That also is privileged, and that is consistent with the evidence code, which indicates that corporate boards can meet with their lawyers, and that information is privileged. Now, just because it's privileged doesn't mean that it isn't gonna, that it can't be released, but only the client has the right to waive the privilege. And the client is the board. It is not an individual director. Individual directors are bound by their fiduciary obligation to keep confidential communications confidential. There may be plenty of reasons why a board would want to waive privilege, and that's something to be discussed with a lawyer. But there are implications to waivers. If you agree to release one letter on a subject from the lawyer, there is an argument that the board has waived the privilege concerning all the other communications concerning that same subject. So you definitely want to chat with counsel about that. Now, one of the issues that comes up where there is a waiver that is very, very surprising to people. You all know that you have a fiduciary duty to act in the association's best interest, to do your due diligence, weigh your options. And when you make decisions, those decisions are protected by something called the business judgment rule. It's just sort of the opposite side of the coin of if you do your fiduciary duty, the law is going to back you up. But when your decisions are based on advice of counsel, and when there's a lawsuit and one of your defenses to the lawsuit is, hey, our lawyer gave us that advice, then you have waived the privilege that otherwise would have attached to that communication and advice to the lawyer. I'll tell you where this comes up. So when associations get sued, sometimes the lawyer who's defending them was appointed by the insurance company. And many of these insurance defense lawyers are very good. Some of them, it's not really their expertise. HOA law, they just do a lot of work for that insurer. They're on what's called the insurance company panel, their panel counsel. They may not be hep to the politics inside a community, what happens at board meetings. And so they may very well plead business judgment rule defenses and inadvertently waive privileges, possibly privileges that would otherwise have existed from prior communications with counsel. So you want your regular corporate counsel to work with defense counsel to make sure that doesn't happen, or at least to talk through the issues. Last, attorney-client communications. Yes, I wrote a letter, 15 years ago about voting and recalls, but the law's changed 5 times since then. So just because you got an opinion in the past doesn't mean that opinion would be valid, continue to be valid now. Let's see the next screen, Connor. Okay, so this is our last screen. So sometimes, you're not going to be happy with a lawyer, and you don't like the opinion she gave, or the fees were too high, or the opinion was incomplete, or you disagree with it, or it was late, whatever. And so if the lawyer has been good, then you want to show them the respect of preserving a relationship, because you don't want to just throw away all the knowledge they have about your community. And you want to be reasonable and fair with any vendor, not just a lawyer, and have the disputes be based on that and not politics. Many lawyers, not all, but many will be amenable to reducing their fees, writing off fees, providing credits, when it's fair to do. I'll tell you my own philosophy for our firm. I like to be fair with the client, and I like when the client is fair with us. That's the basis of a good relationship, because inevitably bumps are going to happen in any important relationship, certainly with management and certainly with lawyers. And the question isn't whether the bumps will occur, but how do we address them? Can we address them and maintain mutual respect in that? For the law firm, if we have a chance to save a relationship, if let's say for some reason the board is not happy with me, but they like one of our senior counsel, Lisa Black, who is on this call, then I'll say, why don't you work with Lisa, and then I'm done. And then if there's some institutional thing, then she'll say, hey, Steve, a couple of years ago, this issue with Fred Jones came up, what can you tell me? A lawyer should not have the ego to care who in their firm is doing the work, assuming the people that could do it are capable. We want to keep the client, we want to keep the relationship, And if you think the firm is a good one, and most times it's been good, that would be something, that you'd want to get, you'd want to preserve if you can. Every now and then you could go to the partner, in the firm, somebody whose name is on the door or not. If you have a complaint, don't hesitate to do that. You don't owe us an apology. You don't owe the associate an apology. That's the client. We know you're responsible and accountable to your members. And so we want to be able to accommodate that, and we should, whether we want to or not. All right. I suppose I should have picked a higher note for my last comment, Dave, but there you go. I see we have about 10,000 questions here. Where should we start?
Well, I'll tell you what we're going to do. Thank you, Steve. That was outstanding. And I'm glad we have a little bit of time here now to answer these questions. So I'm going to ask the attendees to go to the Q&A box and go to the upvote, the most upvotes, and just pick your little thumbs up. You'll see the thumbs up on the questions that you want answered first, and then we'll go by those and let Steve take the first questions with the most votes. That'd be great. So while you're doing that, I'm also going to run just a quick survey. I'm just curious to see the composition of our audience today. And if you wouldn't mind filling that out, it'll be really quick. So Connor's running the poll right now. While we take just 30 seconds. Steve, I'm going to ask you a question. If you were an HOA board member, what are the top 3 questions you'd want to ask an attorney?
Do you have bandwidth? Is your experience in representing HOAs consistent with the kind of issues that are going to come up for our association? And I know I'm not going to get the name big shot guy all the time. Who else are we going to work with, and can we interview that person as well? And yeah, those are the 3 that occur to me.
Yeah, those are good ones. I get.
Can I answer some of these, Dave? I like these.
Okay.
If the attorney is only speaking with the president, how do we know the board can be sure the president is accurately communicating all advice? Number 1, you can't be sure. You have to trust the president. If you don't trust the president, you need a different president. Secondly, the board can adopt a policy. All communications get copied to all directors. There you go.
That's easy. Okay.
How about this one? Lynn asked a good question.
Okay.
Can the association release HOA legal invoices? Answer, yes. And in fact, Davis Sterling, I think, requires the release of some of the legal invoices. Now, Lynn, the issue is the content of the invoices. Because if the content reveals attorney-client privilege, then you're waiving that privilege, not just as to the invoices, but perhaps for the letters that are referenced in the invoices. Now, so it's one thing to show the members how much has been spent for lawyers. That's fine. In my opinion, you should not release the invoices without having a discussion as to counsel about how best to do that.
That's good. So you can see the demographics there on the screen. You should be able to see that it's mostly board members, as we discussed earlier. We have some self-managed and we have some professionally managed, and a few industry professionals and a few others. So there you go. Next one up on the top there. Can the board, where is it? Okay, you can see Judy's question there.
Can one board member come to the attorney, or is the whole board required? Judy, this is a terrific question and drives us bonkers. The president calls and says, what do you think about blah, blah, blah? We send a bill. The board says, well, the president didn't authorize that. So what the lawyer should do is say to the director, are you authorized to have me look at this and incur the expense? That would be the best thing for the lawyer to do. And any of the lawyers at our firm on this call, I hope that's what you're doing. Now, over the years, like I have clients that are many, we've been doing their work since we opened. And I know if so-and-so is going to call, I know it'll be fine. But if the lawyer doesn't know the client and the board, then everybody should be on guard about not having the lawyer do stuff, that wasn't authorized.
So Steve, what if it's the manager that's calling you? I mean, that talks about.
Well, as a matter of fact, a very valuable ECHO member recently told me that her client refused to pay our bill because even though the prior manager asked for it, the board hadn't approved it. And I bit my tongue and I kicked my waist bin and I wrote the fee off, but I wasn't happy. Because we lawyers have to rely on the managers. We have to assume, Dave, that the manager has the right to ask the question. And again, there's a failure of the board-manager relationship if the manager doesn't.
Sounds good. Okay.
Yeah.
What happens, right? Okay, so Judy, let's see. 14. Well, that's pretty good. Okay, 12. That's a lot. Go ahead and
Yeah. So do we have to follow any election deadlines in the governing documents? Okay, first, let me give you the belt and suspenders answer, and then let me give you the real answer. The belt and suspenders answer is yes, follow the dates. The real answer is, at least, and this would be, I like this question, Dave, because this is about how the lawyer has to use his or her judgment and know the facts and weigh things. Why can't we follow the mandated election dates? What's come up? Was it unforeseen? Are we talking about an election where it's not contested? There are only 2 candidates for 3 positions. Is it something like a $5 million special assessment? So there's a lot to know before we can say to the board, you were not complying with the election dates required. There is a risk of challenge. Here's what would happen. But if you do this, this, and this, the chances that the risk will occur or be successful are way lower. And I know some people may think, oh, that's a lawyer wishy-washy answer. But we lawyers, we don't make the call. And, can the board deviate? I don't know. I mean, it just really depends on whether, there would be, it'd be basically, is it reasonable to do so? And have we told members, and have we told them why? And would reasonable people agree that's a good reason to deviate?
Makes sense. Okay, next question from an anonymous attendee. 9 of.
So what happens when the management company has a lawyer on staff? Should the board or trust that or get an outside attorney for important issues? So there's no rule of thumb here. I think that the board should meet with that lawyer, find out whether they're any good or not. Let's assume they're good, okay? And then ask them, what are the situations where, you might have your manager employee hat on compared to being completely 100% devoted to us. And in those situations, the board needs to get outside counsel and the in-house lawyer needs to tell them that. But other than that, and I know that there are lawyers in the industry who will probably shoot me for saying this. Other than that, I don't know that it's inherently wrong to use the management company lawyer. Much as I wish it was, but no.
Okay, so.
But again, there's a level of trust here involved, and it's the same whether it's an outside lawyer or the management company lawyer. And the board needs to eyeball that person and be comfortable with them.
Okay, so the top question is, with 10 upvotes that's remaining here, is how can a board member convey to the board the importance of updating governing documents? Their documents are 40 years old. And
well, I suppose the short answer is because if everyone is relying on the documents and the documents conflict with the law, then the board is subjecting the association to not just liability and lawsuits, but a loss of confidence in the ability of the board to properly carry out its responsibility. So it's a confidence issue and a legal liability issue.
there's a practical cost there too, because things have changed since the 40 years ago.
Well, I mean,
Yeah.
yes.
A little bit.
They've changed since 10 minutes ago.
Yeah, exactly. Okay, so Suzanne Cole asks, if a board and one of its directors has a dispute with each other, does the HOA have to retain separate attorneys for the parties to the dispute?
That is an awesome question.
That's a good question.
The answer is a little tricky. So the short answer is The individual director is free to get their own lawyer. The association's lawyer is speaking for the board. There may be a little new and is acting on behalf of the board. You know, there may be some nuances about conflicts in there, you know, based on prior opinions and all that. But the board has no duty to pay a director who wants to get their own legal opinion about something or to defend them. Absolutely not.
Next one is
Well, okay, let me say. So there is a nuance here. This is we do not have any time for this. I happen to be writing an article with two other lawyers from around the country. When there is a lawsuit against the directors and the association, and the insurance company isn't covering it, and the association has to pay, do they also have to pay to defend the director? And that's not as obvious an answer as you would think. So sorry to be uncertain about that one, but that's deep in the weeds. Most of the time, the answer no, association doesn't have to pay for a director to get their own lawyer.
okay. So the next question is from Timothy. In an effort to save on legal costs, when dues and assessments are not paid, our treasurer writes initial letters of lateness. Lateness, I guess it is.
No, I get it.
Yeah.
I'm not going to answer that question specifically, but let me say this. An association should be using a collection professional. The laws are very nitpicky. They're very complicated. If you screw them up, you have to start the foreclosure process all over again. Most outsized companies do this on a contingency basis, basically. And I would not recommend the association getting deep into the collection process.
Okay.
Can one board member give a rule waiver without the board? Okay, no. And the reason for that is something I mentioned earlier about waiver of the attorney-client privilege. No individual director has the right to speak for the board unless they're authorized by the board to do so. So no.
Okay, Lynn has a couple questions here. Do you want to take either of those?
I only see anonymous.
Are you in the upvotes? It's 7.
Oh, I'm sorry. Let me see. Upvotes. Hold on.
Okay.
Most upvotes. Dave. Well, Dave, why don't you tell me what it is while I'm looking?
Okay. What is the next step when HOA board meetings,
Got it.
in executive session summary? You got it? Okay.
Yeah. So what is the next step when the board only discloses? Well, okay, what is the next step? So at the minutes at the next regular meeting should say, hey, the board met in executive session 2 months ago and we discussed foreclosures and potential contract formation. Pick it up a month later.
Yeah.
Lynn, you ask a lot of questions. Right. What is the next step? No, we just answered that. Sorry. Barbara Johnson. Big fan. I'm a big fan. Can the board meet in executive discussion? That is a great question. Can the board meet without the lawyer if they're looking at the letter from the lawyer? And in my opinion, Barbara, the answer is yes. Now, let me say that when you hear a lawyer say, in my opinion, then that's a judgment call. But in my opinion, yes. And the reason for that is because having the lawyer there doesn't really add to the issue. The issue is the board is evaluating some legal issue. They're evaluating consequences contained in the letter. So I think it's fine, yes.
Okay. Next one is from Lynn.
There's that Lynn again. All right, what are the next steps a member can take when the HOA ignores an IDR request? Lynn must not be on the board. So the civil code requires the board to agree. And if not, I guess you could, I'd send them another request and I'd send them a request for mediation as well. And after that, if your issue is a big deal, I'd get a lawyer. I don't know.
Is ADR not a solution there?
I'm sorry. Yeah, so IDR for everybody means internal dispute resolution. And it's a law that really the legislature intended to require the board to appoint at least one person to meet eyeball to eyeball with an owner before we get lawyers involved in a lot of expenses. The meeting could be down at Starbucks. It doesn't have to be any formal thing, and there's no obligation that everyone agree to a solution at that meeting. What Dave has asked is about the more elaborate alternative dispute resolution, which is mediation, an outside mediator, you're paying fees, there's probably a lawyer involved. It is more of a big deal. Yeah.
And those are both found in David Sterling, so you can.
Yeah. I want to answer Angela's question.
Okay.
What is a reasonable response time when the board president emails the HOA attorney? So to me, that's a hard question to answer. And frankly, in part because I personally, I'm not as fast as I wish I could always be. So let me just say, definitely within 2 days, definitely. Now, if it is urgent and the client and the lawyer have a good relationship, if it says urgent, you ought to expect the lawyer to get back right away, or at least have the secretary or a paralegal or a colleague write and say, hey, we got this, Steve's out, I'm looking at it, I'll get back to you, something like that.
Okay.
What would I recommend to the board or manager that doesn't enforce any of the rules? Well, first of all, the manager has no power other than what the board instructs the manager to do or what the manager is required to do by contract. So the manager may have a crappy attitude and they may be very heavy-handed, but at the end of the day, the failure to enforce is a failure of board leadership. And if it's really bad and there are really problems, then 5% of the members can initiate a special meeting. The board has to set it, talk about the issues, or even a recall election.
Okay.
What can be done when you have a board member who goes on social media and reveals the board member by name with the attorney is, I don't really know what that means, but I would say this. If a board member is on social media without the approval of the board needs to take action on that. There needs to be a hearing. I don't know. I personally am not particularly, I don't really think that censure is an effective technique, but that person can be removed as an officer. The board can create committees to deal with issues and exclude that board member from them so that they're not privy to the information, so they can't go blabbing on social media, which is a way of waiving attorney-client privilege. So that's bad. That's bad. Let's go down a couple, Dave. Let's see what James says. What protocol process do you recommend regarding attorney-client privilege and the manager? So I'm not sure I know exactly, but the manager as an agent of the board who reasonably needs to communicate with or from the lawyer is protected by the attorney-client privilege. So there are, every now and then, there's a board that will say, don't include the manager. And when they say that, usually I want to call the president and I want to know why. And that's not good, not healthy. If you're paying a management company nowadays, they're all usually trained. Some are better than others. Some managers are better than others. You need a good fit. But if the board doesn't trust the manager with their legal stuff, then that's a problem.
Okay.
Oh my God. I love this question. Anonymous attendee. Hey Dave, these are good questions your people ask. Pardon me. Is it okay for the board to draft plain language policy or amendment to the CC&Rs and ask the attorney to look it over for accuracy and comment to avoid a cumbersome document? Much easier for members to read bullet points versus legalese. So our firm has a department that does governing documents. This is not a pitch for our work. But if we got that, we wouldn't do it. We just wouldn't do it. It's just like I wouldn't try to, fix my balcony, then have a contractor come by and ask, hey, did I do it right? There are boards that form committees, and then the committee spends months or a year or more putting together a draft. They write the words, they send it to us, and then internally we groan. Do we really want to work with this client? Because we're now going to have to look at the original documents and the new version and compare those to the draft template that we have perfected over 40 years. So the cost has just gone up a lot. That's the first thing. Second thing is, we're going to be making somebody mad. These probably are good people, dedicated people who spent a long time going through this stuff, and we're going to tell them, basically, we're not going to use it because we have a template, and the price quote we gave to the board was based on our template, and you want to use our template because we've refined it after working with hundreds and hundreds of associations. And when I say me, I mean any of my colleagues. And everything I've said here today, by the way, pretty much any good HOA lawyer would be telling you. So no, in my opinion, no. And plain language, the idea of longer versus shorter documents, that's a tough one. The shorter the document, the easier it is to read. That also means there's a lot of very vague sentences in it, and then everyone projects the answer they want. The longer document is probably clinically better, probably more legally accurate, probably provides better clarity, but on the other hand, people don't read it, and so that's not good either. So there's a mix.
So we'll take a few more here, Stephen.
Okay, look at this. We had an HOA attorney quote us $2,000 to revise our bylaws, but later she charged us extra to attend a board meeting where we discussed the right. So I like this the last line that I can see from anonymous attendee. By the way, I hope you anonymous attendees are members of ECHO, because you're certainly getting your money's worth today. I can't even talk anymore. You know, usually I charge by the word, so I try to fit a lot of words into my answers. Look at that last line there, Dave. We thought the 2,000 fee would cover all work. This is what I was talking about earlier. Let's make sure before we do the deal that we and the lawyer understand the parameters. And it's always a good question to say to the lawyer, boy, I hope you're right. I hope it is only 2,000. But you know, what might influence that to cost more? The lawyer might say, well, if you asked me to come to a meeting, okay, well, we thought that was included. The lawyer says, no, this is just for me to use my template and, you know, figure out what's current with Davis Sterling and up to date. I gave you what you asked for. So again, it's about a good relationship and having the discussion. It's always a good question, I guess, to ask the lawyer. It just occurred to me now. Hey, what might influence the issue that your fees will end up costing more than what your estimate is?
Good answer. Okay, so Linda Radigan has a question here.
Oh my God. Do individual homeowners who are not on the board have the right to access the HOA's lawyer? At whose expense? So Dave gets this question all the time because he wanted me the very first thing we talked about today was, for whom does the lawyer work? The answer is not individual homeowners. And in fact, if I get a call from a homeowner, I won't take it. I will have my assistant take it and say, you need to speak with the association. If the board would like us to look into this, we will. We try to say that nicely. Some people don't react in a nice way, but that's the issue. And by the way, it also can be the same when we get a call from a director, you know, that we've never dealt with and don't know.
Good, yeah. Good answer. Appreciate it. Okay, and Annie says, can a board give the manager a blanket pre-approval to speak with the attorney?
Not only, yes, and not only that, I have many clients who they've worked with the manager a long time. The manager, you know, may be versed, you know, in common management practices. They know, and they're comfortable with the lawyer, and they just call. I have many clients where they don't even ask me the cost. I've been working with them 10, 5, 15 years, and then it works. So really, that's, again, it's a quality of relationship issue. I would say in the beginning, probably not a good idea, but after everybody gets to know each other, then I think it's fine myself.
Mm-hmm. Well, Jerry asks about hourly rates versus retainers. What do you see mostly? The benefits of either too.
So we're on the same page. A retainer has two different meanings. One meaning is a retainer is like a deposit. So I estimate a project is going to cost $20,000 and I want the client to pay the first 10 up front. We apply that to the fees. So let's call that the deposit retainer. The other retainer, Dave, is a little different. And in our firm, we call it the legal services plan. Other firms, this is not as popular as it used to be, where the lawyer will charge a flat fee of X. And then for that flat fee, the lawyer will do this, and this at no extra cost. So for example, in our firm, the retainer would be for unlimited number of short emails we reply to where we can answer without needing to look up the law or look at documents. We might attend 3 half-day mediations. We might go to 1 manual meeting and 3 board meetings. We might do the annual audit letter, or we might send, up to 5 enforcement letters, like that. So it really depends. It really depends on the issues and again, the quality of the relationship.
Okay, so Steve, I think we need to take one more question and then we'll move on with the program.
You pick it, Dave. You're like the dealer at Las Vegas.
I'm the dealer in Las Vegas. Okay. Okay, let's take Maddie's Morgan's question here. Is it customary for legal agreements with legal firms to include a retainer these days? What's the normal? Well, that's kind of, we just answered that one, didn't we?
Well, I would say I don't think it's customary in the HOA world to expect a retainer, with the one exception, and that is the governing document amendment process. And I think all firms that do will require, and ours do too, the deposit retainer.
Okay, sounds good. Appreciate that. So let's go ahead and move on. I want to say thank you to Steve Weil for an excellent, outstanding presentation and for answering all the questions. We had a lot of questions today, and nothing is really all that simple. And when you start talking about HOAs, and he does a great job of simplifying things, and that's really a very valuable skill. So thank you, Steve, for that.
Thank you, David. Appreciate it, everybody. Connor, thank you for helping me look as good as I possibly could. Thank you.
Okay, so I want to say thank you to the ECHO members for coming today and supporting our ongoing ECHO webinars. For those of you joining today who are not members, you're invited to become a member. You or your community can join by going to echo-ca.org and clicking on the membership tab. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to encourage a person to become a member of ECHO. Please help us grow ECHO and continue our excellence in HOA education.
Hey, Dave,
yes.
Can I make the point that the ECHO fees are really low, but it's just part of the normal HOA budget for education. And relative to fiduciary duty defenses, it's very nice to be able to say we're members of ECHO and we pay attention to the information they provide us.
Right, and we appreciate that, Steve, and we are expanding ECHO at this point. We really appreciate everybody. If you would like to become more involved with ECHO, we have some opportunities for you. Please refer to the slide and see if anything looks interesting to you. Please let me know. Send me an email. I'd be happy to talk with you. Currently, we're looking for volunteers to help us with some of our events, especially our resource panels and our educational seminars. We are moving from just webinars due to COVID to in-person meetings. So now we have a particular need for that. So it would be helpful if someone could step up. And we would love some help on social media posting. And that's not one of the great benefits that are one of the things that I do well. So I really would like somebody who likes to do social media and be helpful in posting. Now for our other announcements, our Wine Country Resource Panel will meet in person on June 6th from 11:30 a.m. to 1 p.m. at the Roanoke Park Library. We will be discussing the costs and types of insurance. So insurance fees have been going through the roofs. I would love to have some of you participate in that. The next ECHO Board Members Club meeting is June 13th. It meets via Zoom every second Tuesday of the month from 5:30 to 7 p.m. Tentatively, the topic of the next meeting will be how the board should address potential legal situations. So a nice follow-on from today's conversation. The BMC, or Board Members Club meeting, is open only to ECHO members who serve or have served on an HOA board. These highly interactive peer-to-peer learning opportunities are scheduled from 5:30 to 7 and our Zoom meetings. Please contact Connor at echo-ca.org to learn more about the ECHO Board Members Club and for an application to join. Once again, thank you to our sponsors for making this workshop possible. Thank you to Steve Wild for developing and presenting the material. And of course, thanks to all of you for attending today and making this event a success. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.